abstentions? Hearing none. The next item is item number 8, even though it says item 6, it is item 8.
To consider and act upon a resolution adopting amendments to the Town Council standing rules, whereas the Town Council of the Town of East Haven adopted standing rules governing the conduct of its meetings effective January 6, 2016, and whereas the Town Council appointed a subcommittee for the purpose of reviewing the existing standing rules, identifying necessary updates, and making a recommendation to the full Town Council, and whereas the subcommittee has completed its review and has submitted recommended amendments to the Town Council for adoption by resolution, and whereas the Town Council has determined that provisions of the standing rules should be clarified and updated to reflect current requirements under the Connecticut Freedom of Information Act, including Connecticut General Statutes 1-210, as well as applicable Freedom of Information Commission precedent and Connecticut appellate case law. And whereas the proposed amendments are intended to clarify the purpose and scope of public comment and public hearings, distinguish between agendas and supporting material, preserve attorney-client privilege communications, and more clearly define the authority of the chairperson to conduct meetings in a fair, orderly, and content-neutral manner. And whereas the Town Council has reviewed a complete packet, including an executive summary draft, amendment language, and supporting analysis. Now therefore, be it resolved by the Town Council of the Town of East Haven, number 1, adoption amendments. The amendments to the Town Council standing rules are presented to the Town Council, incorporated herein by reference and hereby adopted. Number 2, effective date. The amended standing rules should take effect immediately upon adoption.
May I have a motion?
So moved.
Second? Mike, do you want to talk about
Okay,
this?
I'll just give you a quick summary. So, as indicated in the resolution, the standing rules were adopted in 2016. They have not been updated. There's been significant changes to case law, significant advanced developments with respect to Freedom of Information Commission decisions, and as indicated in case law, how public meetings should occur, meeting conduct, and how public records should be handled. So we want to make sure that our rules are updated and evolve consistent, with that. And I think we also want to be clear on how the chairman's authority to control meetings, accept public comment, and that it is exercised, and we want that well documented. So I think there's 3 or 4 points that I want to make with respect to the changes. So the key changes, and you've seen, I think, a comparison. I think part of the proposal I gave you. And I just said this first. I want to thank Lou. I want to thank Vice Chairman Pacelli. I want to thank Councilwoman Mary Ann Caesar and Councilman Janetti, who I've spoken with and obviously reviewed the materials that you have as well as the subcommittee. So thank you. I know everyone's busy. Public comment. There was really no clear definition in our original rules what the statement of purpose was, and now we're defining it as input for the record, not a question and answer session or debate. I know that we're struggling with that. This is the only board that we've had that issue with. We made some clarifications for finance. We certainly want records clear to the zoning board of appeals and planning and zoning commission. So we wanted to update these rules to be consistent with that, to remove any confusion and align with otherwise precedent. Another thing that we have when there are questions or comments, we want things to come through the chair. Speakers must address the chair, no direct question to council member, staff, or applicants, should that be the case here. It prevents meetings from turning into a cross-examination or back and forth exchange. Again, preserving the record is important, and I'll talk to you a little bit at the end about the record. I also wanted to make sure that the authority was for the chairperson was clearly defined. It was way too broad and not structured enough in the existing rules. I'm not saying they were wrong, it's just things have changed and I think we want to be more clear. So the chair may impose time limits. I know there's been 3 minutes, that's been imposed. Have the authority to stop repetitive and disruptive comments. That has been an issue on occasion. But to enforce rules in a content neutral manner. So we want to establish guidelines. clear legally defensible authority to manage meetings. Obviously, time limits, as I've indicated, and that will be uniform time limits for all speakers, not allow speakers to submit their time to another. It allows us to move meetings forward in a fair and efficient way. I also put in and updated, I shouldn't say I put in, we updated the definition between, and the differences between agendas and backup materials. It was not addressed in the previous standing rules. Obviously, agendas must be posted, which our clerk takes care of through the town clerk's office. Backup materials that you receive are public records. They're not required to be provided in advance. It's an FOI request that will be provided for the meeting, because obviously they're subject, depending on the volume, but that should not be an issue, and they are available upon request. It reduces FOI disputes and unreal expectations about how everything and things should be posted. The other thing that was not listed, and I think we've had more of, at least as I start to present information to you and make recommendations, is the attorney-client privilege and how it's explicitly protected. The new rule, and again, consistent with case law and FOI rulings, legal memoranda from town attorneys are privileged and they are exempt from disclosure. So it prevents waiver arguments and protects legal strategies. Now, there are points in times where stuff in those memoranda may become public, but we want them protected at various times leading up to that public record. And the other thing I think that's very important, and again, it's to protect the record, is there's no obligation for counsel or staff to respond to an individual who may question it in public comment. How many times you've seen me sit here and not respond? It's difficult, I get it, but we want it to be fairly specific and have the public understand that it's just simply reinforcing the structure of public comment and avoids legal exposure. So let me give you a definition of the record. The record is the official body of information the council relies on in making a decision. So we're creating a record for you to make a decision. It includes agenda, minutes, materials submitted, and all comments formally made during the meeting. It does not include things that are attorney-client privilege or side conversations that may be had outside of a formal meeting. And what we're trying to do is protect the record to ensure that decisions are based, your decisions are based on clear documented information that can be reviewed and defended if challenged down the road. It might not be us, it could be 3 years from now. We obviously, you all recall, we had the Quarry lawsuit, and I can tell you that various records, we went all the way back to 2016, 15 in some instances, and they were part of a lawsuit that was occurring, in 2024. So that's
Joe
how
Santino
important.
was the only one that was around.
Yeah, that's how important those things are. So certainly, I think you have the information in front of you that lays it all out. I'll entertain any questions if anyone.
Questions from the council?
Yeah,
Go ahead.
so is this protecting public speech? I mean, we're not going to limit people, we're not going to make sure that people don't get a chance to vote, right?
That's not the intent.
You instituted the public comment when you came down, it wasn't even part of the meeting before that.
Correct.
Now, recently, well, since we've had no public comment, and I was wondering if we were planning to reopen that and
Well, here's the problem, that, my thought process with that was to, as the first chairman in 40 years, I'll note, to add that to the agenda, to give the public an opportunity to speak about something that is not on the agenda. However, we've seen that it's gotten way out of control. And after deliberating at Administrative Services and beyond, we thought that it would be more appropriate if anybody has anything to say that's not on the agenda, that they could put it in writing and send us an email. That's always the best option, and we could discuss it as administration, probably settle it without coming in front of the public. With that being said, we're not taking public comment away from any of the agenda items. So anything that's still on the agenda, the public will still have an opportunity to speak about it, which we don't want to keep people quiet, if that's the term that we're hearing. We want to give people an opportunity to speak about what's on the agenda, so we're not taking that away. But we are going to, Lou and I will be very strict about the 3-minute, you know. It's going to be you have 30 seconds to finish up, and now you're done. With the implementation of these microphones, the chair microphone can shut off that microphone remotely, and that's what will happen. If it continues to be a disturbance, we'll ask the person to leave and then, you know, take the proper channels to make sure that they're, you know, not disrupting the meeting. So the short answer is, no, I don't intend to put that item back on the agenda because we've had such issues with it, and it's gotten out of control. And the people that come to the meeting, the public that come to the meeting, also reach out to me and Lou and the administration just as much as they talk, you know, so it's just disrespectful to the council, and it's disrespectful to the public that come here to learn about what's going on in the agenda, and I don't think that's fair. So that's the short answer.
I agree with that, but I also could feel that the public feels like they're in touch with the people they elected to take, you know, to represent them.
Sure.
So I just want to make sure that we're not going to curtail their allowed time to speak.
No,
And I really wish you would put, you know, that last item.
thank you for your input.
And just to be clear, there's nothing in the changes we're making that would limit anyone's ability, should it be on an agenda, obviously with respect to public hearings and stuff like that. It's just creating rules that make it more
More tools to
Right.
control.
Yeah.
And you know,
It would be hard to try to enforce, because I know we've sat through them. It would be hard to try to enforce, but again, I just feel like it really keeps the public in touch with.
I also want to make it a point to note that we, as a town, as a council, do not have to have public comment at public hearings. But the public hearings are just to present the information to the public. We're not cutting that off. Other towns, when you go to other towns, at their legislative board, whether it be the selectmen or the council, you don't get to talk to them. There is no public comment. So that's important to note that we are still allowing public comment. So we're not shutting off public comment, especially at public hearings, which is very, you know, I think disrespectful to the public to not allow this. So,
Thank you.
you're welcome. Anybody else? Yes, we could always do that for Robert's rules. We could always, you know, recess, you know, and stop the meeting if we have to. Anything else? Okay, public comment. Anybody from the public have anything to say about our changes? Just state your name and record, and you have 3 minutes. Just say goodbye. There you go.
Anthony Canzano, 48 Hugh Street. I know it's not back and forth, but my concerns are the addition of the attorney-client privileges being protected. What was the intent on that, and can eventually expand upon that. And also, what information needs to be attorney-client privileged, since the attorney is for the town of East Haven. What specific things besides tragedy, that's understandable. But what are the things that need to be hidden from the public that is going on behind the scenes that we don't need to know about or shouldn't know about? That was pretty much it. Thanks.
Thank you. Anybody else? Okay, may I have a motion?
Second.
Second, let's do a roll call. Joey, second.
Ann Pennington,
Yes.
Mariano Santiago,
Yes.
Alphonse Camera,
Yes.
Joseph Deco,
Yes.
Karen Martin,
Yes.
Joseph Santino,
Yes.
Mary Ann Caesar,
Yes.
Louis Pacelli,
Yes.
Joseph Porcali, Michael Janetti,
Yes.
Tina Richard Esposito,
Yes.
Albert Volano,
Yes.
Guy Bamonte.
Yes.
All in favor, motion carried.
Thank you. Okay, Item number 8. Actually, that would be item number 9. Right? Hold on a minute. Let me just make sure that we changed something. 8. So that would be item number 9. 9. No, for that.
To consider and act upon setting a public hearing date of May 5th, 2026 for ordinance entitled, "An Ordinance Concerning Street Takeovers and Related Public Safety Violations."
May I have a motion?
So moved.
Second?
Second.
Again, this will just be public hearing number 2 in May. All in favor?
Aye.
Any abstain? And any opposition? Hearing none. Item number 10.
To consider and act upon the reappointment of Roger Centrich to the Urban Renewal Agency for a term to expire January 31st, 2029.
A motion?
So moved.
Second?
Second.
Any discussion? Okay, all in favor?
Aye.
Any opposed? Any abstentions? Okay, before you make a motion for item number 11, we're going to include the following. The members of the town council, Ed Sabatino, Rich Capola, Mayor Carfora, Attorney Mike Luzzi, Attorney John Staffstrom of Pullman and Conley. So you can make that motion.
Consider and act upon a 2/3 vote of the town council to convene into executive session pursuant to CGS 1-206E and 1-210B10 to discuss with legal counsel strategy and opinions relative to the proposed expansion of Tweed Haven Airport.
Motion?
So moved.
Second?
Second.
All in favor?
Aye.
It's 8:04. Just to note, we will not make any decisions or any actions in executive session. We will adjourn right from executive session.